The evolution of the Web3 economy, by which I mean the trading of digital assets and the use of decentralized ledger technology, the blockchain technology, prompts important thinking about what dispute resolution might look like and ought to look like in the Web3 space. That current technology is disruptive of international arbitration is a truism. But that this disruption demands no less than the complete reassessment of certain first principles and of what it now means to be a lawyer, a disputes lawyer, and an arbitrator right now is, I would argue, an imperative call for our field in modern times. Technology is offering the opportunity to rewrite the rules and the concepts that underpin dispute resolution, and to make the process more accessible, less convoluted, in other words, fitter for the purposes of 21st century commerce. In looking at a dispute resolution system for any field of endeavor, for any industry, one must look first at the values that underpin the field of endeavor and the industry. If dispute resolution is to be successful as a structure of governance, it must garner the trust of its users. And how does it do that? It garners the trust of users by responding to their values, by being responsive to what they look for in the space where they operate and where their disputes arise. So what are the values that underpin the Web3 ecosystem? Well, it's a work in progress. It's a recent phenomenon. But as things stand, we can observe a space where time is very short. Transactions are immediate. They are voluminous in number. They are affordable. They're accessible to the greatest number. They take place directly between peers in a peer-maintained platform, and peer validation matters to the development of that platform. So these peers are, as you know, often anonymous. To be of value in that space, a dispute resolution system must likewise deliver affordable, accessible, near immediate results that are practical, that are peer validated, and that allow the users to continue interacting, to continue transacting. What do we see in present day arbitration that matches these values? Not a lot as things stand. Arbitration is a time-heavy procedure, and perhaps the biggest source of time consumption is the machinery of procedural fairness, what we call due process. The first challenge, therefore, is to rethink what due process might mean in a technology-driven environment. And I will return to this a little bit later in this talk. So this is a practical question. What is great about technology is that it poses really practical challenges. But when one starts opening a particular box of rethinking fundamental tenets, all sorts of existential questions start popping. And I will mention a few of those here. The role of the rule of law, of which arbitration is an important guardian, the role of the rule of law in its respect for the dignity of human agency, the place of that dignity in a coded environment, the intervention of human intelligence in the application of legal rules, as opposed to their mechanistical utilization, the displacement of human intelligence when algorithmic systems enter the field of law, the place of knowledge, and legal knowledge particularly, as distinguished from the information and data that is processed and repurposed by algorithms and by algorithmic tools. The tension between the promise of more speed, more accuracy in the digestion of voluminous data on the one hand, with, on the other hand, the time reliance and biases that come with the human factor in decision-making. So it is a very great privilege for me to be with you today to deliver this address. And it is a tall order to address such big questions in a manner that does them justice. So I will be modest, and I will aim to do no more tonight than to share a few observations on the phenomena that are the development of the Web3 economy and the meteoric rise of artificial intelligence. I would like to outline some of the synapses that these phenomena create with the practice of arbitration in the first instance, and I will end with a few remarks on what technology means for the role of arbitration as an instrument for upholding the rule of law. And we will start with arbitration intelligence. So AI is, to put it in very shortly, the algorithmic processing and generating of data sets. Generative AI, exemplified by the large language models that ChatGPT is the best known example, they can be used to create new content, including audio, code, images, text, simulations, videos, and so on. AI is a reality. Pretending that it does not exist or that it's going to go away, and that it cannot assist or improve on human effort is not an option. The users of arbitration live in the real world, and they welcome the efficiency and savings of time and cost that AI promises when it is applied ethically, critically, and intelligently. Under the umbrella of challenges that generative AI presents for arbitration, I am focusing tonight on the gathering of evidence, and secondly, on retaining the human oversight and control in decision-making that everyone extols on this topic. And I'm going to say a bit more about this. So there are guidelines that are starting to emerge. I'm sure you know many of them. Earlier this year, the UK Bar Council put out some guidelines on large language model and what that means for the world of advocacy. The Silicon Valley Arbitration and Mediation Center they have a work in progress of guidelines specific to arbitration concerning the use of AI. The AAA has also put forward some guidelines as well. All of these converge in warning about the preservation of confidential information, proprietary information and data protection, checking out the hallucinations and biases that can appear in AI output, and the importance of maintaining human oversight and judgment. There's also regulation in the guise of the AI Act, more prominently, that I think aims to be like the GDPR, a little bit of the gold standard that will be put out there, and that other regulations coming afterwards will sort of measure themselves against. And it has a risk-based approach. I'm not going to walk you through it. Suffice it to know at this stage that it specifically singles out the use of AI in judicial and arbitral decision-making and applying the law to the facts. If you use AI to do this, it is considered a high-risk activity under the AI Act, where you have impermissible risk, high risk, medium, and low, so quite high up, which means that obviously the AI that will be used in that space, in our space, will have to meet certain very high standards of transparency and maintenance in order to be acceptable, to fall under the Act. So under that, under this sort of background, I wanted to talk about the gathering of evidence and what AI might mean in that field. And this is, I think, quite a practical, immediate problem, because there are tools that exist, algorithmic tools that exist, for example, in the field of public procurement. There are tools that exist to identify instances of abuses of public funds. And this has been around for a few years. In my role as co-chair of the ICC task force on allegations of corruption, we are currently looking at using algorithmic tools to assist tribunals in identifying red flags in this year of corruption. And so this is something we're looking at with the help of technical consultants. We're looking at not only what the AI can do, but what it cannot do so well. so that we know exactly the type of help that can be provided. And of course, the biggest immediate challenge for arbitration in that sort of space is that we are looking at a tool that is there that can really help tribunal digesting a lot of data, finding patterns that the human mind finds difficult to process given just the volume of information. So a tool that can really be groundbreaking. But what do we have as a process in arbitration? We have a process that spent the past 20 years trying to minimize data and information that is given to a tribunal, streamline it as much as possible. And so now we are faced with a tool that could help tremendously in bringing these allegations of corruption finally to the fore and to be dealt with. And yet we find ourselves with a dearth of data. I don't have a solution to this, except to say that we have to look at the process very closely in order to be able to leverage the help that these tools can give us and not shut ourselves away from it. So that's one example of the gathering of evidence. The other example is something where I'm going to use my little slides. So I've done a couple of things. One thing that I find quite interesting about AI is you can have now text-to-image algorithms. So you give a prompt in normal language, and the algorithm essentially sifts through the data that it's been fed and comes up with an image. And so I did that with quite a crude algorithm that you can find online. It's free, so don't expect. So here, my prompt was, it's called Lexica. My prompt was, lawyer delighted to have won in court. And this is what the algorithm Lexica gave me. Interestingly, I kept putting in lawyer to see what other lawyers, but I kept getting white men. And so I had to put in female lawyer elated to have won in court. And here's what I got. She looks like she's about to punch me in the nose. But you can see straight away the importance of what we call prompt engineering. The lawyers of the future will have to be quite good at teasing out of the machine exactly what it is that they want. Because if you're not precise enough, like in this case, you get something that the coder thought lawyers were male by default, let's just say. Or at least that's the result that we get. And so this I thought was quite interesting. And my other slide, which I hope will work, this is a much more sophisticated tool developed by OpenAI. And it is, to my knowledge, not yet commercialized. But what it does is it takes your prompt and it essentially creates a video. And so Sora is the name, and I'm going to try to play it. It's about a couple of minutes. So look at the prompt. That's the important. Sorry. So you can see, first of all, there are two things here that struck me anyway. The first thing is the impact that this has on the human brain, just the visual and the wow factor of this technology. And secondly, projecting a little bit, not so far forward, is the revolution that this promises for expert testimony, right? Especially, let's think about the Formula One race in San Francisco, for example. And let's think about a big infrastructure case. Instead of getting this high of Excel spreadsheets and reports, I'm going to get a video that shows me a reconstruction of where the problems occurred and how they occurred. And site visits are a thing of the past. And at the same time, the impact of that technology on the human brain is tremendous. How the decision maker distances themselves to probe, whether that technology shows you what you should be seeing as opposed to what counsel wants you to see, is something that is not yet explored, but something that I think has great, great promise. And again, at the moment, this is probably, I would imagine, because the important thing to recall is we are at the dawn of what AI can do, right? It's very early days, and these are often, I imagine, quite expensive ways of presenting evidence, although more expensive than expert witnesses, I don't know, but expensive. But all of this is going to mainstream itself, and the cost, as always, and the cost will be probably more affordable as time goes on. So when I talk about immediate challenges that AI presents to the arbitration process, this is what I'm talking about. To say a word now about something that I think is absolutely crucial and important in this field, and that all the guidelines that I talked about, keep banging on about: human oversight, humans must remain at the core of the process. What I call the last kilometer must remain human. Now, the guidance is largely silent on how the humans manage to remain relevant. It says we must remain relevant, but does not tell us how. And again, when one is faced with what we just saw with Sora, how do I remain relevant when faced with evidence like this? How do I question? How do I step away? I was recently reminded of Lord Denning's insistence of words as the lawyer's tool of trade. He said, I'm going to quote him, "When you are called upon to address a judge, it is your words which count most. When you have to interpret a section in a statute or a paragraph in a regulation, you have to study the very words. You have to discover the meaning, analyzing the words one by one to the very last syllable. On the words you use, your client's future may depend." And then he says, and it is on this that I want to focus, the reason why words are so important is because words are the vehicle of thought. When you're working out a problem on your own, you think in words, not in symbols and not in numbers. When you are advising your client, you must use words. There is no other means available. And those words ring especially strongly when we are faced with an algorithm, ChatGPT and equivalent, large language models, that uses words, the very and the only human vehicle of thought as a means of conveying its output. What is the human mind to make of these AI-generated words? Are they a vehicle of thought? And here we touch upon the feature of anthropomorphism, the sort of human-like characteristic that OpenAI has literally endowed ChatGPT. The mere fact that it's called ChatGPT, we can speak to it in normal human language, not even not even scholarly, everyday language, colloquialism. And they present a challenge to the human minds, these algorithms, these LLMs, because they talk back at you using the same language. And so to the human mind, the LLM's ability to speak human and to understand conversational prompts acts as a very powerful but false indicator that there must also be human intelligence and human understanding and human logic at work behind the algorithmic rhetoric. And the UK Bar Council, in its 2024 guidance, ranks this feature first in the list of risks inherent to LLMs. And I'm going to quote them. They say, they are designed and marketed in such a way as to give the impression that the user is interacting with something that has human characteristics. One of the mechanisms by which this is sought to be achieved is by the use of anthropomorphic language to describe what is happening. Perhaps the most obvious example of this is the use by OpenAI of the word chat in the name of its LLM. As we say, LLMs, at least in the current stage of their development, do not have human characteristics in any relevant sense. Specifically, they are not a conventional research tool, do not analyze the content of data, do not think for themselves. And it's very, very difficult for the human mind to resist that inference when you are conversing in the only vehicle of thought that we are gifted with. Accuracy and truth do not yet feature in an algorithm trained to predict word associations. I'm going to now leave the question of practicalities and say a little bit about, I said I would say a word about what this all means for the rule of law and the role of international arbitration as an instrument for the guardianship and the application of the rule of law, which was reminded to us as recently as last autumn by Lord Neuberger at the ICC conference. It is arbitration is part of the human element of governance and the rule of law. And there is a school of scholarship on legal philosophy that terms it thoughtfulness and the rule of law. And it's a school of thought that posits the following, that human beings want to be ruled thoughtfully, or to put it in a democratic idiom, we want our engagement in governance to be thoughtful and reasoned rather than rigid and mechanical. So when looking at international arbitration as an instrument of the rule of law, it's important to recall that the rule of law rests on pillars of procedural and institutional values. And tenets such as procedural due process, the independence of the judiciary, the responsibility of the legal profession, all of this is part of the fabric of the rule of law and of its thoughtful application. The author says, in this regard, law has a dignitarian aspect. It conceives of the people who live under it as bearers of reason and intelligence. And so this brings to the fore the question of the time factor that I was talking about earlier, the time factor inherent to the thoughtful application of the rule of law. Procedural due process contributes prominently to the time-consuming aspects of international arbitration. And I have argued elsewhere that due process, as currently conceived of and applied, also sits uneasily with the values of the actors of the Web3 economy, which are, as we mentioned earlier, the instantaneousness of transaction, the immediacy of outcome, and trust in dispute management by a community of one's peers rather than by an institutional centralized body. Algorithmic tools, large language models, and the automation of legal processes by way of smart contracts are being deployed as a means of streamlining the dispute process with the very laudable view of providing cheaper, more accessible justice. It's a valid question to ask in what manner this affects the application of the rule of law, weighing the place of thoughtfulness on the one hand, and expedient effective justice on the other. In closing, I will say just very simply the following. What constitutes justice in the Web3 economy, and whether this is an economy that will embrace a new concept of justice that finds it worthwhile to trade in the rule of law for immediate automated outcomes? These are important questions for future consideration and development. For the time being, so long as we consider it worthwhile for the rule of law to continue to have a place in modern society, alongside the tremendous advantages offered by technology, then the last kilometer must remain human. Emerging regulations, such as the AI Act, aims to provide us with some processes that will enable this. However, I'm not sure that these processes are sufficient to address the challenges of the human mind in distancing itself from algorithm words as a vehicle of thought. Perhaps the true challenge for dispute resolution in the 21st century is to deliver a carefully balanced process that retains the thoughtful, human-centric application of the rule of law, while at the same time producing prompt, accurate, trust-garnering justice. If you want to know more about these, I'm going to do a shameless plug. You should go to arbtech.io, which is the website that where you will find a lot of discussion on these topics, and a lexicon, a glossary, podcasts. We have quite a lot of things that are aiming to educate, train, create dialogue, bring attention. Thank you very much.